identify its requirements to allow it to be completed. And it would say you need to do X, Y, and Z, go get your shareholder approval, go do this, go do that. And if you do all those things, you are allowed to close. And then on the 17th, you would go to the exchange and say, we've closed, and we've met all of your conditions. And the exchange would then issue its final approval. So I guess it depends, what did Belmont tell the exchange? Did Belmont tell the exchange, oh, by the way, this company was dissolved under Utah law, but don't worry, that has no legal impact because we, Belmont, have obtained a Utah opinion? I don't know.
What about, forget about Utah law, let's say it's Congo, another country. The purchaser comes from Congo, so that we're not under Utah law. And assume that under Congo law, the purchaser, once he's dissolved, cannot carry out the transaction. Would an approval of the shareholders meeting of a public company to proceed with a share purchase agreement be affected in any way under Canadian law?
The shareholder approval, no, but the actual completion of the transaction, if you're saying you're trying to complete a transaction with somebody that doesn't exist and has no ability to exist, then I would think the answer should be no, because you're missing one of the key elements of the transaction, a party.
But the resolution itself would not be affected under Canadian law by the fact that I'm working on the assumption that the company did not know about the fact that it was dissolved. Wouldn't the resolution under Canadian law be affected?
No, so the resolution, so the directors have the power to do whatever they want to do,
Yes.
subject in the statute to half a dozen exceptions. One of those exceptions is the directors do not have the power to sell all or substantially all the undertaking of the company without first receiving a special resolution of the shareholders.
Okay.
And so the directors were unable to complete this transaction until the shareholders authorized the directors to do so at the shareholder meeting on July 16th.
Okay, but the authorization to do so, is it impacted by the fact that they did not know before giving the authorization that the purchaser was a dissolved company? Under Congo law, they could not proceed. Would that under Canadian law? Canadian law
No, the shareholder approval is a box that has now been ticked. The directors have the ability to enter into and complete the transaction. But if you're saying that there is no party in existence on the other side of the transaction, then how can you transact if the party doesn't exist?
Okay, but I just want to last time make sure that you are with me. You're saying that the authorization given without knowledge that the company, the purchaser, is dissolved, is not by this fact alone void. You're saying it becomes impossible to perform because the purchaser is dissolved. Those are two separate things. But is your testimony that under Canadian law, that consent given is not void? Because
That's correct.
what?
That's correct. The consent is not void.
Is not void.
Is not void.
It's voidable?
It's given. It's not voidable, it is given.
It is given irrespective whether the authorization was given that the purchaser was dissolved. That's your testimony.
The authorization was authorizing the directors to sell
Okay.
all or substantially all of the assets
Okay.
to a party on the terms identified in the share
Okay.
purchase
Okay.
agreement as transcribed into the information circular.
Okay, what about then the
question
directors?
is-
The
Sorry.
directors, they take it to the next step. The authorization was given to the directors to
Right.
enter into the contract. How about the directors closure, is the closure which occurred according to you void because the directors who closed according to you at the time, they did not know that they were dealing with a dissolved company which under Congo law could not carry out the transaction.
Well, as I say, if you're saying that the thing did not exist,
Yeah.
then yes, it's a nullity that did not exist. You and I can't reach an agreement if we don't exist. We can't.
No, it's
But-
not, I'm talking about the consent, it's the consent of the seller, is it a consent full, that is,
I'm saying the shareholder approval is done. The directors no longer have an impediment to their power to enter into and complete this transaction. However, the question of whether the contractual counterparty is existing and able to complete the transaction is a question in this case for Utah law, or in your hypothetical is a question for Congo law. Does this person exist?
that was not my question, but I'll ask it within the context of the Canadian Venture Exchange approval, okay? The Canadian Venture Exchange final approval of a public company, isn't it void for public policy reasons? Because, well, if you start with a no before I answer my question, then
It's not void for public policy reasons. It's not
okay,
void.
avoidable?
No, you've got to remember, the final consent is
Yeah.
not given prior to completion of the transaction. It's given after completion of the transaction. It is telling the exchange, we have completed the transaction, and the exchange says, great, tick, stamp, you're done.
It is telling them, but at the time, imagine that the purchaser doesn't know that the purchaser is allowing a listed company to close, okay, a sell purchase agreement with a company that is dissolved. I mean, don't you think that is a material information?
If the approval to close was given on May 16th, if I have my date correct, the final approval is not permission to close. The conditional approval is the permission to close. The final approval is something that's saying, we've closed our file, the transaction is completed. That certificate or approval is issued on the basis of what Belmont told the TSXV, as it's now called. If what you're saying is, we lied to the TSXV, and does that vitiate the TSX's closure of their file and their
Not
approval?
lying, is that it was not disclosed by the purchaser, and that the seller didn't know, and as a result of that, the security did not know that, and this is a listed company. I cannot understand how this could not
Well, no,
avoid the conflict
you
of
either
consent.
close or you don't. And if there's a party to close with, which is a question of Congo law, and you have closed, you've told the exchange you've closed, and the exchange says, thank you very much.
Okay.
If there's no party in existence and it's impossible to close, and you tell the exchange, I closed, clearly you were wrong if it's impossible to close, and yes, the exchange would have issued their approval and closed their file on the basis of your incorrect representation to them, you should have said, I'm sorry, we haven't closed because the counterparty has disappeared.
Forget about whether or not the purchaser, once dissolved, can or not carry out the transaction. So whether it's Congo law or Utah law, doesn't matter. Assume he can carry out the transaction to close once dissolved. The mere information, new information that was not disclosed to the shareholders, the directors that entered into the company, or the Canadian Venture Exchange that gave its final approval, wouldn't that by itself be a material element that would void or render the approval voidable? Because you would allow then a listed company, with all the consequences to the shareholders, to enter into a transaction, not knowing that it is entering into that transaction with a dissolved company.
Mr. Anderson will answer, but then
Yes.
will not ask the same question of fourth or fifth line.
I think maybe I could make headway this time though, because I think I've got a way to address this. So perhaps you misunderstand the nature and scope of the TSXs.
Maybe,
So,
and the approval.
so the
And the approval of
TSXV,
the shareholders, not
yeah, so the
issue.
TSXV only regulates those people who obtain a listing with the TSXV. And it prohibits people from undertaking material fundamental transactions without getting their approval. If you violate that and do it without getting their approval, their only remedy is not to say that the transaction you completed was void. Their only remedy is to say, I don't like you anymore, I'm delisting your shares because you don't follow my rules. So the TSXV, the Canadian Venture Exchange at that time, or the Vancouver Stock Exchange before then, has no power, unlike a court, to void or rescind or otherwise impact a transaction.
And then you can complete the quick question, to answer with respect to a company, Belmont. Try to help me, I retain you. I say to you, I entered into a contract with a purchaser. Once I entered into the contract, I didn't know that that company was dissolved. Now, I don't care if that company can carry out or not the transaction, but I would never have closed with a company like that had it not disclosed that, had it disclosed that it was dissolved. Under Canadian law, do I have a remedy for that?
Yes, to sue that company.
To do what? Sue to do what?
I guess, I don't know what damages would flow, but you would argue that there has been some breach of the reps and warranties or covenants in this agreement,
Okay.
and you would sue to recover damages.
Or to get out of the contract.
I don't know whether this is a situation that would entitle you to rescind.
Now, going back on Article 6, I want to engage with you on your interpretation as of the date the contract was entered into, okay? So, and if I read Article 6 closing, it says, the ownership of the shares shall not pass to the purchaser, okay? And then I turn the next page, it says, unless and until the vendor has received 125% of its initial investment. And it has a set amount.
3 million Canadian, yes?
So, I mean, I cannot find anything clearer. It says it has to go into a trust. The trust was not there. Then it says the ownership of the shares shall not pass to the purchaser. Then it says unless and until. So can you explain to me why practically you would want to these clear provisions not to apply?
So, this goes back to exactly what we were talking
Yes.
about half an hour ago. And
From a
this
practical
several-
perspective, if you can.
So,
engage on
absolutely.
that.
So, to me, this is a bet as to whether or not these shares would achieve if they were sold, achieve 3 million in sale proceeds. And if they don't achieve 3 million in sale proceeds, there is no ability to improve or supplement the proceeds that were received. There is no ability to give additional shares. I have sold the purchase price shares, the 12 million shares. I've received X, hypothetically, let's say 1.5 million. I've received 1.5 million. I guess I've got no further obligations because I did not receive 3 million. So where is the ability, the guarantee that everybody talked about in all the disclosure? When this deal was sold to the shareholders, nobody talked about Article 6. everybody talked about 4.1B and 4.1C. They said, we've got to guarantee, these shares, we're guaranteed to get money out of them, because if they're sold,
Can you just,
Mr. Chairman, I think the witness should be allowed to finish his answer.
what point of time are you talking about then? When you say, when you're talking about the guarantee? I'm with you at 2011.
let's go to 2001. Let's go to the
2001,
shareholders
sorry.
circular. The shareholders were described this transaction and told, please approve it. The shareholders were told in the proxy circular that this is what the deal is. We're selling our 57% interest. We can actually go to that document if you like, but let me paraphrase for now, and then we can go to that document. The shareholders were told, I, Belmont, want to sell all or substantially all of my assets. It's this 57%. I'm selling it to EuroGas. EuroGas is giving me 12 million shares, they're giving me 2% royalty, they're giving me a variety of things. And good news, shareholders, if these shares go down in value and they reproduce 4.1B, and if I sell the shares for less than 3 million, they reproduce 4.1C in the circular, saying this is what happens, shareholders. Nowhere in the circular does it say anything about, oh, but if we sell all the shares for $1.5 million, nothing happens. We just won our bet, our gambling bet.
But this is
That's not what the deal was. That's not what's been described to shareholders. Before we even closed the transaction, we described something different.
But this is what.
Can we have the reference of this circular?
It's R109.
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 I'm with you, you know, you're a practitioner, correct?
Yes.
I'm at Article 6. What I see in the hypothesis that $3 million are not reached, I do not see why the parties cannot implement remedies to cure that. This is what I don't understand. I mean, you can go to C, you can issue shares, you can pay an amount.
But
Why couldn't
no,
you cure
it
that?
doesn't say that. It doesn't say, please sell your shares, and if there's a shortfall of less than 3 million, then the shares will be released if the purchaser pays more cash. It doesn't say that here. What it says in 4.1B and C is nothing about topping up the cash. It says pay an additional number of shares calculated based on a historical price
To reach them.
that bears no relationship to what you might sell them for, and those aren't purchase price shares. Those aren't the 12 million. So this just does not work, and that's why I've come to the conclusion that this is sloppy shorthand for people to refer back to 4.1B and 4.1C. And that's what the circular says.
But sloppiness is something, practical possibilities to remedy it in practice are another.
And yes, and that's exactly what my expert report goes into, that we use these rules of interpretation to start with the plain meaning, and when that arrives at an unreasonable result or a commercially inappropriate result, we then go to the intent. And as I say, when in this R0109 on page 8, when Belmont was describing this transaction to its shareholders, at the end of the second paragraph on page 8, the last sentence, it says the value represented by the payment shares shall be guaranteed by the following formula, and then A and B, and it reproduces 4.1. It doesn't say anything about, Article 6 sort of gives us this strange unknown top-up or something. It says nothing about that.
But it has the ownership of the shares that do not pass Belmont. So the sloppiness basically that you're describing is a problem of the purchaser that could be remedied either by the issuance of new shares to meet that, the payment of the amount, or if it is with a counterparty that is a seller that is acting in bad faith, avoiding performance by an action before the courts, either for restitution, either for unjust enrichment, other thing.
But,
That's the.
but then you're falling into the trap of rewriting the contract that we've agreed a long time ago under Principle 1. What are the principles? That we don't rewrite or redo a contract for parties. And that's exactly my point. We're not redoing this contract. Article 6, if you read it, has a brand new right that nobody talked about anywhere to realize 3 million. And is not capable of remedy in the contract itself. But what is a real remedy and is capable of, without correcting or rewriting the contract for the parties, 4.1 B and C, or sorry, C and D provide for exactly what you're saying the court should write into the contract.
So the event the vendor is unable, 4.1, then there are shares that are issued to meet the 3 million threshold. So what-
Correct, yes, I agree,
So it-
4.1C.
So it's the sloppiness that you identified is expressly provided at C. So I just don't understand why are you, what's the problem? Why you need to rewrite first?
Well, you need to rewrite. You're the one that said we need to add to Article 6 the ability to top up in cash so that somebody gets cash.
I said if there are problems you cannot, you need to cure, but if it's the 3 million shortfall, there is no problem. It's written 4.1, you issue shares to meet the 3 million. In practice, that's what happened. They tried to issue shares to meet that threshold.
But-
What sloppiness?
But there's nothing, so you realize $1 from the sale of the shares, you give me the notice as required within the 1 year,
Yes.
and I give you, let's assume, 12 million more shares because the price for some odd reason is back to where it was. What's happened now? Have you realized 3 million from the sale of the purchase price shares within the first year? No, you've not. You've realized $1 and you've got a bunch of top-up shares.
Okay.
What does Article 6 say happens? Article 6 says you've not received your $3 million and so there's no, you haven't transferred the shares. That's the commercial absurdity. And that's why I'm saying that 6.1, this is not hard stuff, right? This is like, let's look at this. It's obvious that they.
What obvious? Start again. You issue shares. At the time you issue shares, do you know that this is not ridiculous, that it cannot be $1 amount? You have an idea because the shares exist, right? They're quoted.
Yes?
So on its face, if it was $1, that would be absurd perhaps. But you have an existing base and there is no bet. It protects the seller to make sure that it hits at least this amount, okay? And if it doesn't hit that amount, there is an express why rewriting contract at 4.1C, okay?
So at a minimum, you are asking me to rewrite this to say the vendor has received 125% of its initial investment equal to Canadian 3 million through the sale of the purchase price shares together with any other shares that are issued by the buyer under 4.1C or 4.1B, and the vendor has an additional year period during which to reasonably sell those shares and realize these proceeds. So you're asking me to add a whole paragraph to Article 6 instead of looking at paragraph 4.1 that says exactly what happens.
Sir, I'm not asking you to write anything. There are two issues. I'll get to the rewriting part. One, why do you need rewriting if Article 6 is clear? I mean, I'm reading it, and I think in your expert report, you agree that it's clear. So you say the ownership of the shares shall not pass to the purchaser. And then it goes on to say, unless and until the vendor has received 125% of its initial investment equal to CD and 3 million. Then there is a hypothesis. If that 3 million is not provided for, you say okay, then that would lead to a problem. But that problem, assuming it is one, that would allow you to read out of the terms of the contract is set out at 4.1C. Namely, you issue shares and you hit that. So why do you
Well, no,
need to
just say-
rewrite?
Purchase price shares. How do you hit 3 million from the sale of the purchase price shares?
Then the
You've already
purchaser
sold them
shall,
for 1.5.
then the issuer shall within 10 days of the written request by the issue such additional common shares to compensate for any shortfall.
But those aren't purchase price shares.
Yes, so
So how can you satisfy the clear condition that says I've realized 3 million from the sale of the purchase price shares?
by applying an express remedy provided on the contract under 4.1, which is a warranty.
So the point is,
It's a contract as a whole, no? I
Yeah.
didn't buy
I agree.
this page, I didn't
I
sign this
agree the
page.
contract is read as a whole,
Yes.
and that's exactly why I'm tying Article 6 to Section 4. Because Article 6 cannot be a standalone condition. It
Okay.
can't be a separate remedy. If it is, it's a gamble, it's a bet.
Okay,
Will these shares sell for more than 3 or not?
I already addressed the thing of a bet, because you cannot characterize it as a practitioner as a bet, because the company is listed, so you have a share, and you know it's not gonna be $1. So I think that thing you can,
Well, it is a bet.
$1 hypothesis.
What happened?
you
It turned
can-
into 1.5.
Okay, and then let's go to the final hypothesis that you would need to rewrite that because of sloppiness. Okay, I'm engaging you now with you on the theory of sloppiness, and you would need to rewrite. And that, according to you, would prevent for the application of the terms of the contract. Now, Belmont, I submit to you, is very protected by this contract. It's a very good contract for Belmont. Why? Because it says that we keep the shares, they shall not pass until we meet that threshold. Okay? So we keep the shares, we keep the title, it doesn't pass. So any sloppiness, assuming one, that is not remedied under the contract, that would require something else, is for EuroGas. EuroGas is a professional, and they cannot close. It's their problem. It's a badly negotiated. They didn't hire Mr. Anderson. They should have hired Mr. Anderson of Stikeman Elliott, expert, and maybe we'll do some in the future.
I guess
Okay?
that's where you and I differ, because I'm saying, and hear me loud and hear me clear, I'm saying it would not be interpreted to lead to a commercial absurdity. You're saying it's great if it leads to a commercial absurdity because it's in Belmont's favor, and why would Belmont complain about that? I agree entirely. I've got no dispute with that statement. My dispute is we don't even get there in the first place because the court would just not say that this is what this means.
Well, you qualify it as a commercial absurdity, but you have used the word sloppiness. I would say in the extreme scenario, even with the $1, even I gained you a few with the $1 shares, it would not be a commercial absurdity. It would be a professional that entered into a sloppy contract. And I would read to you the decision that you submitted, that in these circumstances, the holding is, the doctrine, as a result, the applicants should not receive the return of their initial investment in a joint venture. It goes on, the doctrine of unjust enrichment, or the doctrine of whatever you want to rely on absurdity, I would say. The applicants also did not apply. The applicants choose not to pay and suffer the consequences the law prescribed. So it's tough luck. It's a sloppy contract by professionals. According to the case law you cited, Jethro RL 0088, and at paragraph 16 of your statement, you say the absurdity theory should not be interpreted to change the bargain.
That's correct. I agree entirely, and as I say, you are trying to change the bargain by changing Article 6 so that it actually makes some sense and works. And my proposition is no, we don't change it so it makes some sense and works. We don't import reasonableness. We don't import obligations to sell when maybe they want to keep their shares, and that's inconsistent with the remainder of the contract that says you can keep your shares. All of that requires us to rewrite the contract. And my point is that no. The reason it leads to a commercial absurdity is because the person that created the words was sloppy.
Okay, then closify me on this. What happens according to you now? What do I hold, Belmont? According to you, see, I'm engaging all the way with you. Now you won. What do I hold?
I think there's a lot of facts we need to understand because you had a right under 4.1b and 4.1c to sue because your rights were not respected. As far as I know, you did exercise your rights under 4.1b, and I see evidence in the record that Belmont did that and received 3.830,000 additional shares under 4.1b. Belmont also had the right under 4.1c to claim the receipt of additional shares. It either did or did not do that. If it made the request and the contractual obligation was breached by EuroGas, it's open to Belmont to sue, and it holds as security in my vision of the world the 57% interest that provides it a remedy against this company that may or may not be able to meet its obligations anymore. So just like, the bank wants you to pay your mortgage, and if you don't pay your mortgage, it can sue you and then take the house away and realize on that security. Here, Belmont was in the position of holding security over these Rosman shares. Now, I wasn't looking at bankruptcy documents, as you've identified, so I don't know whether it made a claim in the bankruptcy for its entitlements as against those shares or not.
Well, you saw the bankruptcy was the other way around, but I don't want to engage with you again on bankruptcy. See, what do I have now practically? I have the ownership, you agree, on paper, registered. At least you could agree with me that I hold them, right? Belmont.
I agree that Belmont holds it as security, yes.
Okay, so according to you, at the minimum, under Canadian law, I hold them at the very minimum. I mean, I'm with you all the way, how you want. I hold them as a security, okay?
As security.
As a security, okay. Now, there are a few questions related to that. I hold them as a security under Canadian law. That means there has been a security arrangement over the shares, and I understand under Canadian law, and that the concept to turn a ownership of shares into a security is a complex, formal process. Would you agree with me?
No, you can, under the Canadian statute that governs this, it's actually the British Columbia statute, the Personal Property Security Act at this time, the granting of a security interest needs to be evidenced in writing, right here I say, and it can be perfected by possession. And as far as I know, either, and you have to help me with which case it is, either Belmont holds them or the solicitor for Rosman holds them, and that is possession on behalf of Belmont. So it's secured as against other creditors.
Okay, there are a number of things you said. First, there was no trust. So let's work on the assumption there is no trust, okay?
Okay.
So it's Belmont that holds them directly,
Okay.
okay? Then you said another thing, is that this document, you pointed that creates a security. That's the problem I have with you under Canadian law. How could this document, what are the terms, substantively or from a point of view of form and form, meet the test of security under Canadian law? Can you tell us? If you don't know, then you can say you don't know.
I agree with you that I am not a secured transactions or bankruptcy expert. That's not my field of endeavor. However, in conversations with a variety of my colleagues, they suggested to me that this certainly would be something that could form the basis of a security interest, but I can't tell you that out of my own.
Well, that's very.
Belief.
I talked to my colleague that
Yes,
said
no, I
that this
agree.
could form the basis for security. We're
Yes.
far from this meeting the requirements of security. So, once you said that, I see Belmont with full ownership when I read this. Full ownership, unqualified of the shares. Don't I?
Well, you might, but you're not a BC lawyer, and you're not a bankruptcy lawyer, and you're not a secured transactions lawyer. So I don't see how you can say that I read this as not creating a security interest.
Sorry to interrupt. I'd like to understand your opinion exactly. In terms of ownership, who, in your analysis, who owns the 57%?
The beneficial owner is EuroGas.
Beneficial owner.
Yes, so just like if I can make an analogy, in Canada, when I want to buy a house, I'm the kind of person that needs to borrow money from a bank. I then own my house, but that mortgage that was granted to the bank gives the bank, in effect, the legal title to that property. And if, as and when, I fail to make the mortgage payments, the bank can foreclose. And what I have is called the equity of redemption. I'm entitled to make the payments and redeem the interest of the mortgage holder. I think that we can analogize to this situation where there has been a title retention by Belmont as security for the obligations of EuroGas under this agreement, and EuroGas has the equity of redemption to meet its obligations and obtain title to these shares in addition to its beneficial equitable interest, or not. And if it doesn't meet it, then there is a possibility that it can be foreclosed against. The evidence we have in the case, there's a variety of threatening letters and the like made in 2003 and 2004 that talk about we will foreclose, we will sue, we will sell the shares, and if there's a shortfall, we'll come back to recover that from you in a variety of exhibits. I'm trying to remember, one was the Paul Fang lawyer, fall of 2004, and similar letters between the parties that contemplate exactly what I'm describing as being the case.
Is your interpretation compatible with the words, the ownership in a certain situation, the ownership of the shares shall not pass to the purchaser? You said it's becomes the beneficial owner, but is that reconcilable or not with the sentence I just read?
I think so, because as I say, this is a title retention mechanism. This clause doesn't clearly go into detail, but provides for the basic title retention mechanism that forms the basis of the security. So that is exactly what I've been saying throughout my report.
Well, I'm not familiar with these concepts. Where there is a beneficial owner, what is the situation of the other party? How do you characterize it?
Secured, they're a secured party that holds title as security for the obligations. Another example that I can give you is a lessor and lessee of equipment under a capital lease, where there might be a title retention mechanism, and you as the lessee are using your forklift or photocopier every day, and once you've paid out the lease over time, you then get title to that piece of equipment to continue to use it. But during the term of the lease, if you fail to make payments, there can be a foreclosure action by the lessor, and you have the equity of redemption to pay them out, and then you'll own the equipment, or you can walk away, in which case, you know, bad things happen. The property is seized, is sold. But, you know, we're, as I told you a few minutes ago, this is not my area of expertise. I'm not like a secured transaction, bankruptcy kind of lawyer that deals with this.
Okay. Sure, I'm on this with you at the year 2001. And what I have problems with is then you using correspondences afterwards. Remember, because your whole theory was that 2001. So I don't know why in certain responses to help you, you pick and choose correspondences in the future. So focus with me at 2011 because that is your theory. 2001 under Article 6, I read to you what we both agree, in fact, again, are clear terms that the ownership of the shares shall not pass to the purchaser until a condition has been met. You have relied on certain principles of law that you have applied the way you have to arrive at the conclusion that I, Belmont, today hold the shares, this you agree under Canadian law, but as a security. Then I put to you, this is your case, this is not mine, because you bounce back to me, you're not a security lawyer. It's your case. My case is that I'm a full legal owner based on that clear clause, and I don't need to go to that construction. You use that principles to get out, then to say that it's a security. So you have to prove to me, not me to prove to you, that I hold it as a security. And I ask you to cite the provisions of the law that allow you to say that I'm not the legal owner, I'm not the beneficial owner, then I hold it as a security. And I understand your answer was that I did not know. I spoke to a colleague that said this provision may form the basis of a entitlement to security. Do you have anything to add to convince me that I hold it as a security?
Yes, so I need to correct perhaps either what I said or how you summarized it. As I said, the requirements are that it be in writing, and you said I pointed to this, and which words is it that created it? And I told you that the satisfaction of the clause, that the grant of security be in writing is satisfied by this. I didn't say that I don't think a security has been granted, and that's the conclusion a court would arrive at. So I'm convinced that on reading this and the problems in the literal interpretation would cause a court to come to the conclusion that what is really at issue here is there's a guarantee that is represented by 4.1b and 4.1c, and the security for that guarantee is the title retention mechanism in Article 6.
Okay, and under Canadian law of security, can you tell us what provisions of law that you apply to say that this could, under law, these terms, without going back to correspondence in the future, meet the requirements of a security under Canadian law, only as opposed to
it's a case that I would have to present to you that I don't have with me
okay,
today.
so we're in agreement on that. And finally, I would like to even go a further step with you, to say that I hold it, let's assume, as a security. And the beneficial owner I put to you is a bankrupt company since a long time ago. And there is no claim made to me for beneficial ownership either EuroGas 1, EuroGas 2, the bankruptcy, the trustee, there is no claim put. And I've exercised written to the world that I am the owner. What's the solution to this situation under Canadian law and your theory?
Well, I think the answer is actually found under Utah law.
Okay,
as
so, and
opposed
which
to
you don't know
Canadian law.
anything about. So that ends my question. Thank you.
Thank you. Retirement.
Very short, Mr. Chairman. Mr. Anderson, in preparing your report, did you review any documents signed after the SPA in which EuroGas and/or Belmont characterized their deal?
Yes, I reviewed many documents. I think the two principal and most reliable documents from an evidentiary perspective under Canadian law are those that are most contemporaneous with the transaction. And so, to me, the two documents that best represent and are most helpful interpreting the contract are the information circular that was prepared June 8th, I believe, that outlined for the Belmont shareholders what it is they were being asked to approve and what the nature of the transaction was. And the second document is the series of financial statements that report and record what happened as a result of the transaction.
In fact, I think I'm going to take you to those two documents, but before I do, let me just ask you, in all of those statements that you said you reviewed by Belmont and/or EuroGas after the SPA was signed, characterizing their deal, did you find those statements consistent?
I think prior to 2004-05, they were quite either consistent or ambiguous enough that they were capable of any number of interpretations. After roughly 2005, as evidenced by the press releases that you've brought me to, certainly I see evidence of Belmont saying, no, we own the shares by that time.
And in those later statements around that same time, were you also noticing inconsistent statements being made, again, around the same time?
There's also,
That's super leading to your questions. Do you notice, again, inconsistencies?
I don't know if anything in my question suggested what the answer should be.
I think just to identify within the document themselves, for example, in 2003, when somebody says, I'm going to foreclose or recover these shares, it can be capable of two interpretations. One, I own the shares, and one, I hold them as security. So what I was trying to say in the last question, the first time I've ever seen a statement that, no, we hold these shares, it's not a security or anything else, didn't arrive till later. For example, like at the 2006, 2008, 2009, those press releases you showed me or led me to. However, are there contrary statements that you've shown me from that same time period that you provided? Yes, I've certainly seen many statements. For example, the one from the criminal proceeding that specifically stated, no, we had no interest, we sold those shares. So I think there's documents that are on their face contradicting each other later. There are documents that are more ambiguous earlier.
So let's just look very quickly at the two documents you said you found most instructive. The first you said was, this is the information circular.
Yes, you call it a proxy circular in the US. It's the information record that's sent to the shareholders so that they can, the legal test is to have sufficient information to make a reasoned decision.
Okay. And this is, for the record, R109.
Can you point to us which part of this document you find relevant?
The description of the transaction starts at the very bottom of page 1, or sorry, page 7 and it's section 1, disposition of the 57% interest held by the company in Rosman SRO. And it starts out by identifying that a share purchase agreement has been entered into and identifies Rosman as being the owner of the talc deposit. And it goes on to identify the Rosman interest constituting, I think I said earlier 90%, here it says 91, so I was mistaken, 91% of the assets of the company, and that is the reason I mentioned earlier that the shareholders need to approve this, because it's the sale of all or substantially all of the company's undertaking. The transaction is described, and the key point is that the last sentence at the end of the introductory paragraph, second paragraph on the page, says the value represented by the payment shares should be guaranteed by the following formula, and then it goes A and B and reproduces section 4.1 B and C of the share purchase agreement.
Mr. Anderson, I'd like to direct your attention to a different paragraph in that document. On page 12, and I'm focused on the second full paragraph. It's the second paragraph from the end of the summary. Do you see that?
Yes, I do.
Could you just take a moment and read that paragraph?
Yes, I have.
Is the tribunal, you're with me? I noted that this paragraph mentions the 125%.
Correct?
Do you see in this paragraph any mention, as we did in Article 6 from the SPA, that title will not pass unless and until the vendor has received 125% of its initial investment equal to 3 million Canadian?
No, I didn't notice anything anywhere here that talked about the title retention mechanism, although, truth be told, I wasn't so focused on pages 9, 10, 11, and 12, because that's actually a portion of the information circular's a fairness opinion,
Right.
written by a evaluator who is identifying and justifying the purchase price. And so that's not someone that we can rely on to tell us what the legal effect of the purchase agreement is. But
And then the second document I'd like to take you to is one that claimant's counsel took you to, which is R114. These are Belmont audited consolidated financial statements for the years ending January 31st, 2002 and 2001. Counsel took you to tab, and I will tell the tribunal now, there's no need to do so, but he took you to tab 58 to view this document, but that tab only contains a very small portion of the actual financial.
that's correct. When I got there, I said this is missing note 3 that actually describes the
Right,
disposition.
so I think it would be helpful if we all look at the full document, since you had referenced it in both your testimony and since counsel took you to it. So it's R114. I don't have it in a bundle. I'm informed this may be in the witness bundle we had. It was part of Mr. Adiaglish's cross-examination.
Anyway, we have a.
Yeah, okay. I'm gonna, do you have the full exhibit in front of you?
I do.
Oh, excellent. So, just to speed this up, if I know these pages are not numbered, if we flip forward. Mr. Anderson, just before I get to my question, you indicated you found this document significant. Why is that?
Well, it provided a variety of evidentiary information for me as to the nature of the transaction and what happened. And given that this is the first set of financials that were produced immediately afterwards and during the financial year in which the transaction occurred. And it deals with the disposition both in note 2, significant accounting policies. And in note 2A, it describes the fact that as a result of the sale, the Rosman results are no longer being consolidated into Belmont's results because it's no longer, Rosman is no longer a subsidiary, which,
So how did they book this transaction?
well, as a sale, it's no longer a subsidiary.
And-
Suggesting that, as I said earlier, the shares are held as security only. And then in note 3, we're no longer just talking about accounting policies, we're actually giving a lot of more detailed information about the disposition of the subsidiary and what the transaction involved and what was received or not received in connection with the transaction. And there was 2 points. I think I was originally led here to talk about the NRAR, the advanced royalties. And I think there was some debate about whether or not 76 or some other amount had been received. And note 3, Romanet 3, says payment by EuroGas of 100 US as advanced royalties. And it goes on to say subsequently net recovery to Belmont of 96,774. I don't, so I think when we originally talked about this, the suggestion was that 100 was aspirational and some other amount was probably received. I don't know what subsequently net recovery means, but certainly I see there they've got 96,774. And then they go on to describe the market guarantee and the fact that the shares of the 57% interest are held as security for that market guarantee. And then lastly, the piece that had me scratching my head was Romanet 2 at the bottom of this page.
And just so the tribunal can follow, what page are you on?
There is no page number, but I'm in note 3, the second page of note 3, and it's
Well, we
Romanet
first have
2.
to find note 3.
So note 3 is disposition of subsidiary.
Which page? I mean, let's
Um,
tell us, let you tell us how many pages we have to turn from the beginning or from the
Is
end.
it the last page? No?
So after the statements, which double-sided is 1, 2, 3 pages, there are notes to the consolidated financial statements. And note 3 starts at the bottom of the 4th page of those notes. And in between double lines,
Note 3.
there's a heading 3, disposition of subsidiary.
Okay, disposition of subsidiary. We are at note 3, disposition of subsidiary.
Right.
And can you specify for the tribunal the subsection you're under?
So earlier, when we were talking about the NRAR, I was on this initial page. I was in the Romanet 3, so III, that says payment by EuroGas of 100 US as advanced royalties.
And which provision in the SPA do you think that connects with?
The 100,000 NRAR, the non-refundable advanced royalty. And then the second thing I was pointing out, that at the top of the next page, under Romanet 1, it describes the market guarantee that was provided by the shareholders and summarizes 4.1B and 4.1C of the SPA.
pas sur le la disposition du style de l'excellence. La cellule, on ne sait pas. Pas du
Yes, I think we're with you.
And then the last thing that I was noting in passing is on this same second page of note 3 at the bottom, there's a Roman number 2 that speaks to the fair value of the repricing of the 2.5 million share purchase warrants under the agreement has been estimated using the Black-Scholes model. And that is, as I say, something I was uncertain about because it's not dealt with anywhere in the share purchase agreement. But if these financial statements are saying it happened, this is additional consideration that was received. I wasn't sure why this additional consideration was received and whether it has anything to do with the payment of the NRR or something else. I just don't know. But clearly there is evidence here that the transaction didn't unfold exactly as the share purchase agreement contemplated.
But can you tell us what's the reasoning to come to the conclusion that your interpretation is correct based on this? Because we see what is written, but where's the reasoning?
The first note under significant accounting policies identifies the fact that the 57% has been disposed of and is no longer being consolidated as a
And maybe Mr. Anderson could point to the specific language to refer to.
in note 2A, consolidation, there's a subheading called SSRO. If you skip after that, there's a subheading called Rosman SRO. And the words underneath that Rosman heading are: the company sold its 57% interest in Rosman SRO, effective March 27, 2001. The accounts and operations of Rosman have been consolidated in the accounts up to the date of disposition. It goes on to speak to the gain arising as a result of the disposition.
Is there any language on the next page you might point to?
And
Why
after
don't you do that then?
after the table identifying the values that are being ascribed to the various components of the consideration being received for the 57% interest, it goes on in 2 key paragraphs to say that the company holds the Rosman shares pending settlement of the amount of the guarantee shares to be issued, and completion of the U.S. registration statement, which requires the inclusion of certain financial information from EuroGas. And the second paragraph says the company has recorded the EuroGas transaction as a sale and disposition of a subsidiary and holds the shares as a collateral measure only. EuroGas acquired effective control of Rosman on March 27, 2001. So those statements would tie directly into what I was suggesting was the correct state of affairs.
May I just ask a material question? When there is a reference to note 3, does it mean that this is note 3 or does it refer to another document that we don't have?
So the title,
Or later in the document, but that still is, that I haven't seen at least.
so the notes themselves have a double bar, or 2 bars, one on top and one on the bottom of the note heading. And then,
It's a reference.
and then when there's a little bold C note 3 or C note 5, it's a
Understood.
reference to the other notes in these financial statements.
Understood.
So, as a, for instance, where we were previously, note 3 meant, please find more information in this note 3 about what I've been describing in note 2A.
And can you explain just again why you think subsection 3 under note 3, I think it's 3 little I if I remember well, is important to your analysis?
Well, that speaks to the receipt of payment. So I think earlier there was a suggestion that there was just a hope that payment would be made, whereas the way I read this, it speaks to a receipt of the payment, and the payment hasn't been satisfied through this net recovery of the 96,000.
Was that one of the conditions preceded?
That's correct.
And your conclusion is, based on this, what?
That the conditions precedent to the transfer of the shares, being the payment of the NRR and the payment of the 12 million consideration shares, had been achieved, and the remainder of the conditions were conditions subsequent that had to be satisfied following completion of the closing, that were secured by way of the security interest in the 57% interest.
Is there anything else about this document that you found particularly relevant to your analysis?
No, I think I touched on all of it. The disposition, the no longer being consolidated because it's not controlled anymore, the amount of proceeds being received, the guarantee being identified, the shares being held as security being identified. And as I say, the big question mark for me was that note 3, number 2, right after the little parenthetical to C note 17, that speaks to the fact that this repricing had been received as consideration and the value calculated using this particular method of valuing.
So that footnote resolved the question for you.
Yes.
Mr. Chairman, I have nothing further.
Thank you.
I have one on your question. I follow up. In this document, it answers the President's question about how you read this to support your conclusion. If the word guarantee here applies, then collateral, and is for you guaranteed shares within that context, followed by collateral measure. Same thing as security under Canadian law? Or these are
Yes.
complete separate things, or you don't know?
No, that's exactly what it suggests to me, that these shares are held as collateral, i.e. as security, for the performance of some obligations.
Okay, but for you, the term guarantee, collateral, and guaranteed shares, and then in that context, collateral measure only means that there is a security.
That's correct.
It meets the provisions of security under Canadian law. Or you're just suggesting that it could?
No, this doesn't meet the conditions for the determination of granting the security. What I'm saying is this describes the fact that a security has been granted, but not by virtue of these financial
But
statements.
please reassure me that I understood after all this, your position in your course correctly, that this document that you rely on is a subsequent document to the exercise that you propose to carry out to reach the conclusion. Because every time I pointed you to further correspondences, you told me in the statements of Belmont and EuroGas, you told me yes, but those for me under Canadian law are irrelevant. So I look at the date of the SPA. Did I understand you correctly?
I didn't say irrelevant, I said the weight to be given
Okay.
to them is much less.
Thank you.
But these, we started out this question about what are the most relevant contemporaneous documents. And my point was that there's one of these documents that was prepared before the transaction was completed, and one prepared, the next set of financial statements prepared afterwards. And so those are as contemporaneous as I had.
Thank you. So thank you, this completes your examination, thank you very much.
Thank you, sorry for being so long.
We have time to start with the next witness. At what time do we break?
We had talked about breaking a little early today, but
Do you want a break on it? Now, a short one.
Mr. Magnon will be conducting this cross-examination. I think a 5-minute break might be helpful just to organize ourselves and move some
Okay,
things out of the way.
fine.
Thank you.
Good afternoon, Mr. Hill.
Good afternoon, Mr. President.
You're here as an expert witness in this case. Can you read please the statement?
I solemnly declare upon my honor and my conscience that my statement will be in accordance with my sincere belief.
Thank you. Time of examination?
No,
He refuses.
I offered, the record shows that I offered.
Okay, then cross.
Thank you, Mr. President. Good afternoon, Mr. Hill. My name is Raul Magnon. I'll be asking you some questions about your expert reports in this case.
Thank you.
So, I'd like to start first with the cost assessment for the development of the mine in your report. I know you're specifically referring to the supplemental report, where I believe you address the issue of cost.
I can open the...
Yes, of course.
Which one are you referring to, please?
The supplemental report, I believe that's that one.
See, this is...
I believe that's both.
Yes, I just wanted to make sure that it was...
Oh, so what we have done, just to give you a little bit of,
Can I just, the microphone, do you switch that other one on? And on this side, would you switch this one off? There's a random one. Thank you very much.
so both of your reports are there,
Thank
and
you.
the binders have some of the exhibits that we're gonna be going over. So, on your supplemental report, page 21, you know when you get there, please.
Thank you.
So at the bottom, there's a section titled Capital Costs.
Yes.
And I see you list there a series of costs which you have divided into 4 categories. Mining, which you take from a prior report, and we'll get to that. Capital costs, operations, processing, and end processing. You see that?
Yes.
And then you have figures on the right-hand side to each of those categories.
Yes, noted.
Now, I've made a rough estimate of converting all of those into euros, and I come up with about 30 million euros, give or take.
Yes.
Would that be accurate?
Yes, I think we came up with the same number into something similar.
Okay, so these capital costs, what exactly, in terms of the development of the mine, how would you describe them?
The development of the mine, this would include putting the ramp in, which you call the winds, and also putting an adit in, which is the raise in. That's the capital development. But I also took out the vent raises
Okay.
to make a balance between using the numbers that were in the original reports, and made a balance between the two.
Okay. And just for the benefit of the tribunal, when you say added, what do you mean by added? Just if you can describe it in layman's terms.
An adit is a horizontal or near horizontal tunnel.
So it would be the opening.
It's the opening, yes.
Okay, so this envisioned the cost of the opening as well.
Yes.
And then I see there the processing, this envisioned also the cost of building the processing plant.
Yes.
And you need that to actually operate the mine?
No, it is in the phase build-up of
Okay.
operating the mine, In the initial 2 years, the processing plant would be under construction, and you would raise funds as normal on basically using minimal processing, selling your crude rock.
Okay.
So this process plant would be built in order to facilitate flotation within year 3 or end of year 2.
Okay, and this processing plant was part of the plan set out by Rosman at the time. At the time, and I'm gonna put a date on that, 2000, the year 2000.
In the year 2000, it was within their, they've got several reports, but within their mine approval, no, it's not. This is within their studies. They were carrying out flotation studies, extensive flotation studies, defining the brightness, the whiteness, and the recoveries that could be obtained from different products.
Okay. My question was a little bit more general. I just want to know if, generally speaking, you know, this processing plant was something that Rosman was envisioning as part of its development, not in the technical sense, but the development of the mine. This is
Yes.
something they wanted to do.
Yes.
Okay, so in essence, they would need the funds, all 30 million euros, to proceed with all of these plans.
No, not all these funds. They would need some of these funds for the primary development, but as I said, they would instigate production on a sort of basic scale, which is actually what's carried out at the moment. And in the first 2 years, you're actually generating funds to enable you to have capital going forward for the process plant build.
Okay, and what would they need for the initial stage? As I think that's
The initial stage, you will need your primary underground development capital.
Okay, and how much are we talking about?
You're probably looking at 15, 18 million
Euros.
euros.
Okay, and you need that just to get off the ground?
Really, yes.
Okay. Now, I see you cite here the DEG report, and you cited, well, that same page. And I'd like to take you through that report, if I may. And I believe it's exhibit C-137, and it is your tab number, it's that standalone document, I believe you have there, right in front of you, isn't it?
Yes.
I believe, is that it?
That's the DEG.
Yes, is that marked C-137?
C-137.
And if the tribunal is there? No, it was I believe it's a standalone document that may have been made available to the tribunal. I'd like to just confirm that they have it now. Let me see if it's available. I believe it was used in the cross-examination of Mr. Rozloznik. So,
Do you know what tab it would be in that bundle? Maybe it's in the index.
just give me 1 second, we're trying to locate that document. It's Mr., I'm sorry, it's Mr. Ayagosha's binder, and then we tab number 10.
We have 2 copies so far.
We should
Tribunal needs a copy.
And it's- We're good.
This document can be found in volume 1 under tab 10. of our cross-examination comments.
Extra set here.
We have one.
Okay, thank you. Apologize for that. Thank you, I apologize for that. So, Mr. Hill, I was referring you to C-137, which is titled Hansa Geomin Report.
Thank you.
And, have you read this report before?
Yes, I've read this report.
Can you just describe for members of the tribunal the nature of this report?
It's a feasibility study carried out in 1998. This is a typical feasibility study at the time, 20 years ago nearly. This would be a standard study carried out for raising funds, a standard study for presenting for a bank for an investment, to cover all elements of the business at a fairly general level, defining the deposit, defining how it's going to be operated, and defining the costs. And this would be the main use. It was generally known as a bankable feasibility study at that time. Feasibility study is the common name. So it would be to raise funds.
Thank you. I just want to ask you a follow-up question. 'Cause I'm a little bit confused, and I want to make sure we get all the documents right. This is not Mr. Heidecker's feasibility study, is it?
No, is it?
This
Are
is
you
a
telling
different.
me?
It's a question, yes.
No, it's not, is it? No,
I
it's a
don't believe it
different
is, but I'm
study.
asking you.
It's a different study.
Okay. Do you know who commissioned this study?
No, I don't think I do, unless it was Dorf, no, but I don't know.
Okay. Would it surprise you if I tell you that it was commissioned by Rosman for purposes of raising funds with DEG?
Not at all,
Okay.
yes.
Now, I'd like to point you to page 33 of the feasibility study, please. C-137. Now, there's a table there that's under total investment cost. Are these the numbers that you reproduce on the capital costs that we saw on your supplemental report earlier?
This isn't a reproduction. As I've written into the preamble for those costs, I drew the costs from here, but also from the 3 ARP studies and the 2000 internal reports, where it is. This is where they're going in 1998. Every year in the development of a business is like stepping stones. So you will adapt your business to your latest thinking.
Okay. So back in '98, these are the capex, so to speak, that we were the costs that were going on.
Yes.
Okay. If you look at the paragraph that starts with the overall investment cost amounts to, and then the second sentence in this paragraph that reads, this part of the investment is further considered as an initial.
Sorry.
I'm sorry, on that same page.
I can't find that the overall.
Exhibit 137, page 33, the paragraph that starts, the overall investment cost, right after the numbers.
Thank you.
And then the second sentence says, this part of the investment is further considered as initial investment cost. You see that?
I see that.
Now, the term initial investment cost is consistent with, this question with what we had discussed earlier, that this were funds needed to just get the project off the ground.
In this report, it's more than that. It is to get the project off the ground into like a phase 1 of operation, because it included the milling and bagging plants, primary crushers, secondary crushers, and screens. So you would actually make a refined product. So it's a step further than the initial kickoff.
Okay.
And you would actually make 4 different products for the different, really targeting different industries. One was a paints and plastics product. One is quite a basic product, and the other one be going, or 2 probably head for the paper industry.
Okay. Did these costs later increased, I believe, as you, is that, I'm sorry, I'm a little confused. Is that what you explained earlier, that some of these costs earlier increased given the ARB studies?
Given the ARP study would be the introduction of flotation.
Okay.
The introduction of flotation, the deposit does have wonderful grade products, but like any deposit, there is a lot of low grade. In order to capture a lower cutoff grade to maximize the deposit, you would have to introduce flotation. To do this milling, your cutoff grade would be over 40%, 40 to 60%. To carry out a flotation, you could take a much lower grade and maximize your recovery from the deposit. The deposit within it, if you come to it, the deposit is weighted into the exploration area as a high grade zone of 60%. So the first area they would be mining would fit this scenario, where you could just do milling with the product, so you could mine it, screen it, and mill it, and you have a new product that is suitable. This sort of high grading isn't long life, but this is the reason to introduce flotation. So you would target the same products, but with a floated product.
Okay.
Another reason to go to the flotation is that they highlighted the pyrite and the graphite within the products. So the graphite and pyrite, into most industries, this is not acceptable. So the flotation would be necessary to take out the impurities, shall we say, the dirty products.
Okay. Right. So it was an integral part of the whole process
What was?
to ferret out the impurities.
Absolutely.
Thanks.
Long term.
Okay. Now, the sentence that follows says, following coverage rates are calculated. And then it talks about credit financing and equity. And it identifies that 60% of those costs are going to be raised by credit financing and 40% by equity. Do you see that?
Yes, I see that.
Now, did you consider the ability of Rosman to raise capital in your report?
No, I did not.
So your estimate in the report that we saw on the supplemental report assumes that Rosman is able to come up with the capital needed.
Yes, my remit only took it to that point. My remit didn't take me on to financing. It wasn't part of my remit.
Okay, and when you said it didn't take it to financing, does it include also, you didn't assess the financial risk of the project? Or just well, let me put it to you.
I assessed the technical risk of the project.
Okay.
The financial risk, I had no view of where the financing was coming from, so that was not included in the financial risk.
Okay,
Just the technical risk.
thank you. Now, sir, you've been sitting throughout this hearing for this week, and you've heard the term de-risk mentioned frequently. Are you familiar with that term?
Absolutely, yes.
Is it an industry standard term?
Terms which mean the same thing.
Yes. What would be your understanding of de-risk?
You have to be secure in your knowledge, I would say would be a fair assessment.
So would it include be secure on the technical aspects and the financial aspects of a mine?
Yes, under the, if you come out of Slovenia, out of the Russian bloc, and you move to things such as the JORC code, since the 2012 JORC code, almost includes that now. Pre the 2012 JORC code, it was a JORC code of 2004, and the previous JORC code rules were slightly different. But certainly since the 2012 JORC code came into place, you would have to de-risk the project financially.
Okay. I'm gonna step ahead on some questions I had about the JORC code, because I saw you mentioned it in your report. Can you explain to the members of the tribunal what the JORC code stands for and what's its purpose?
The JORC code is, there's JORC codes of such different names all over the world, and slightly different interpretations and standards all over the world. The Western bloc, shall we say, Europe, not Europe, that's stretching it, but the old Europe looks onto the JORC code. Canada, Australia looks onto the JORC code. Previously, a technical assessment of a deposit meant if you can mine it, then it's approved. But now the modern JORC code means you have to mine it and be able to sell it. That's the changes in the JORC code. Where before the JORC code was purely, all you had to do was be able to mine it. That is a very basic premise. In Slovenia, they mainly work under a Russian code, which is different classifications, but they haven't moved on to the 2012 JORC code so much. They're still mainly working under like a parallel to the JORC code of 2004, which means if you can mine it, that's the end of it. There's also different interpretations, whether it's an industrial mineral, whether it's diamonds, or if it's a metal. The code, the interpretations are different for the three classifications.
Now, this JORC code, if I'm just correct me if I'm wrong, it has objective standards by which you can define a resource or a reserve.
Absolutely, yes.
Okay, and who relies on these categories of definition for resources and reserves?
Investors,
Okay.
whether it's banks or privates. Very much in the Western world, they rely on the JORC code. The Russias and the old CIS bloc do not rely on the JORC code. They rely on very much the study we're looking at. Studies still like this still pertain in the Russian bloc and in neighbouring countries. A much more simplistic approach than the JORC code.
Okay. Are you familiar with the PERC, or Pan-American European Resources?
Yes. JORC really comes part of that. It's just an umbrella.
Okay.
It comes down. So that's, am I familiar with its interaction? No. But my understanding and behaviour with it, it's an umbrella for different codes similar to the JORC code, because still there's codes within Australia and Canada which are identical to JORC, but it's a different name.
Okay.
So it's an umbrella carrying the codes.
So PERC will govern in Pan-European.
I'm not sure of its governance.
Okay. Are you familiar with PERSCO?
It's similar. It's governance, but equally it's not so much the governance. It's different banking institutions demand different things. So if you were trying to raise funds in the Western area, even if you had a deposit in, shall we say, Russia, or shall we say Slovenia, Slovakia, then they would look for JORC code.
Okay.
But if you went to Russia, they wouldn't be looking for a JORC code, they'd be looking for different parameters.
Okay. And would it be accurate to say that JORC and PERSCO employ the same kind of definitions for purposes of classifying reserves and resources?
So my understanding, yes.
I'd like to show you some of the classifications in the PERSCO standards, just because I think it might be useful. I tend to learn and understand that stuff by being very visual.
Is it pertaining to this site,
What is?
this code,
Well, you just,
to this country?
to which country?
Slovakia. Slovakia is it pertaining? The code doesn't pertain to this country. They work under the Russian codes.
Okay, it may not, well, let me ask you this. Isn't your testimony that Western investors would look at the standards under Crisco?
Absolutely.
Okay,
I agree with you.
I want to take you there, please. It would be, it would be on tab 54.
Thank you.
And this would be Exhibit R 0139. And I'd like you, sir, to turn to page 6 of that exhibit, if you may.
Yes.
Okay, and there's a table there at the top, a figure 1 at the top of page 6. And can you describe to us what that figure shows?
It's the same as the JORC code. It's a general indication from having confidence to invest and confidence to operate. So you go from a confident level of having a mineral resource, and you then go from a confident level to actually invest and operate, and the measure is how you're operating.
Now, would it be accurate to state that if you go to the, under mineral resources and then inferred, that would be one end of the pendulum in terms of risk associated with a project?
No, that's not correct. The pendulum goes further down than that. You have exploration zones, and below that you have exploration potential. So
Okay.
once you get to inferred, I would say you're in the middle of your pendulum. You have identified a mineral resource by drilling or sampling. You have actually secured that you have a resource.
Okay, so you're telling me that, if I understand correctly, that there are two other categories outside of this figure that are more riskier than a inferred mineral resource?
Naturally, these are not categories in there, but when you know nothing about a location, there isn't a category for it. So,
Okay.
and there is, like, for example, a license with no drilling would not be an inferred license. So you would have a license, an exploration license, and there'd be no category on it. So this is obviously a lot riskier than having an area that's been drilled and you've moved into, I wanted to use the word proven, it's not proven, but you've actually drilled and mapped out an area. It was actually brought up by Mr. I forget his name yesterday. Mr. Chari yesterday. He and this is where I've got the same conclusion, which we'll get to, I guess. Mr. Chari had said he'd worked out that he had got a class 3 classification, which is the Russian classifications, or Z3 in Russia, we call it C3, through his drilling programs. So he had moved to that classification, and he had moved further by targeting a high-grade area. So within this deposit, you have a big inferred area. Inferred doesn't mean you want to mine it yet. Inferred tells you have a very good probability. This is what you see is what you get. It's there. To move to indicated, now you have a confidence to go there and mine there. Measured, you actually have to expose the ore body and sample the ore body to get to measured. So this happens when you're actually move underground. So once you get to indicated, this is when you start developing your business, whether you're going to invest and go underground. In this case, they actually drilled an area of more intensity which within my report, which I can draw you to in a minute, I selected, and it's the definition that came out of the reports from Rosamond. They had a extraction area, which they called the first extraction area. But this gave a target to start at, which they targeted their incline, and they targeted their design in 2000. They made a design to run a ramp into that area. There was no measured material identified.
So it wasn't even on this graph, on this chart.
Measured. No, they did not identify any measured, because you have to actually be underground or expose the ore body.
Did they identify an indicated mineral resource?
They had a small area which I would consider as indicated, yes.
Did you see it on their report? Using that?
They didn't call it indicated because they were not working to these standards.
Okay.
Yesterday, Mr. Churi expanded that he had moved to the Russia. He had designed a grid and drilled to the grid. The grid is clear on the drill patterns. You can see the pattern he's followed, and then you can see the concentrated drilling to actually up the levels of confidence for one area.
So you believe it's a indicated mineral resource?
No, I believe the vast bulk of it is inferred.
The vast bulk is
The vast
inferred.
bulk is bulk. There is a small target, from memory, it's just over 1 million tons of indicated. Once they identified this indicated area or high grade area, they then put a very large borehole, but I couldn't actually work it out from the data, but I believe it to be an 8-inch diameter borehole, straight into the middle of that deposit on that area. And that 8-inch borehole wasn't really to sample it. They were fully aware of the grades from the other boreholes in that area. But that was to get bulk material to bring out and then carry out the testing and the quality inspection of the products in bulk. This isn't a borehole just for visual. This is just to get a bulk sample out to give you the confidence. So you would have the primary drilling pattern, which the grid, this would then, they brought to the attention there was a zone, a high grade, so this is now moving into an indicated. But to give you the confidence of the indicated, this large borehole quality, then they could carry out the sampling and testing of how they could process it and manufacture it. So this actually brings this area out of the inferred and puts it into an indicated area, very small area.
Very small.
Very small, of about 1 million tons. This is compared to about 1 billion tons of the whole deposit. There's about 1 billion tons of mineralized ground.
Okay.
So just to get the scope of that small area, that's what I'm just giving the numbers. It's very small. But there's a sufficient tons there. If you target and mine it, that will generate the funds to expand the mine.
And then, so you say that this small area, as compared to the rest of the deposit, are indicated mineral resources.
They were not classified as such by Mr. Churi or Rossman at the time, nor with the current VSK. VSK's report has classified it as an inferred and a target area.
Have you classified it like that in your report?
No, I have not done the calculations, but I can see the amount of drill holes there, the quality of the information, and the quality of the products. And in my opinion, that small area, could I show you the plan?
Yeah, of course, please.
As in my first report, if you turn to page 7,
Which report, sir?
this is my first report.
Okay.
Page 7, there's a plan. This just is a general plan showing the boreholes. The red are showing talc, and the blue are showing no talc.
Okay.
In addition to that, I would point out that there's a couple of holes which are named HO2, HO3. There is an HO1, but I couldn't find it, but the data's there. These are hydrological holes, which is also, this is part of giving confidence of what's going in the deposit, because one of the big constraints and big problems in this deposit is the amount of water. So they'd already progressed into tackling how to tackle the hydrology of the project with those holes. But if I just move on to page 12,
In the first report.
in page 12 in the first report, figure 5.1 is a repeat of the previous plan that you've looked at, and I put a little yellow square in the middle almost. That is what is classified as the first extraction area or the extraction area. So in the scope of things, it's a small extraction area. And the plan below gives a more closer zoom in showing the different drill holes within that area. Within that plan, hole number 43, looking at it, there's 3 in a cluster there, which appears maybe as a wide drill 3 holes in one area, but there's method at times of madness. 26 was an old hole that showed good quality ore. Number 43 was drilled as a check hole. A check hole is really to prove what you have, because number 26 was old drilling from 10, 15 years before. Once they had established that quality and that grid in that area, they drilled this hole number 45, which was the large diameter hole to give you the bulk samples to do your testing from.
Okay.
Just to take that, if I then move on, I'll come back. I've taken the drill hole data, and if you look at figure 6.2, and I've mapped out an envelope. Now, I have not carried out a full, if you like, JORC report, but I developed an envelope, which is all part of like the first step. So you have an envelope there showing the ore body, and the ore body runs through talc bands, which are 400 meters down to 2 meters. The DEG report says it's an average of 200, but I wouldn't like to support that. But certainly there's very thick zones, and it's like a layered cake of talc, no talc. It's very banded, but what it is all part of the folded structure. So all these bands are in there, captured in there. But all that zone in there that was identified by Rosmin has been sort of redeveloped by BSK, and BSK have actually ended up with a larger area of mineralization than Rosman now.
Okay.
They have a larger area. So it's about 2.5 kilometers by 1 kilometer. I think now it's 2.7 kilometers by 1.2 kilometers. So I can understand the excitement going back when the first borehole went in. It's just colossal. This is the excitement. But the thing is, it's an industrial mineral. This is not gold, it's not copper, it's a metal, it's not diamonds, so it's an industrial mineral. And industrial minerals, you can get prices for some, but in the main, industrial minerals is a product of $150, $200 a ton, almost whatever industrial mineral it is.
So how does that relate to, for example, risk? And before I let you answer the question, I would appreciate it you're a little bit shorter in your answer, because we have a lot of ground to cover, and I want to make sure we get to it. And so in terms of risk, when you say that this is an industrial mineral, this is not gold, that means, and I'm asking, this is a question, does that mean that you need to be a little bit more certain before you go into a project of this kind that you would be, for example, let me finish my question, please. For example, if you go in another type of mineral, for example, gold or diamond?
Quite the opposite. Gold's price is $1,340 this week, an ounce. So your investigation to get that right is very heavy. Copper price is about 4,650 price. Talc price per ton is sitting at a bulk product at about 130, 150 euros a ton. So that the actual returns per ton mined is very different for top, far less.
Far less than gold.
Far less.
Okay.
And that's why the levels of scrutiny, if you like, and the levels of investment, to raise funds for a gold mine, you can raise hundreds of millions very fast. To raise funds for an industrial mineral project is very hard work. Because the industrial mineral market, a lot of the industry there's key players, big players, whether it's phosphate or whether it's pyrite or China clay or carbonate, there's key players, but equally there's only key markets to play it into. Where in the metal business and diamonds, this market is much more open. With gold, it's a security, diamonds are security.
Mr. Magnan, there was a perspective yesterday that we would end today at 6. It seems not to be the case, but can you tell us?
I could certainly wrap up this specific topic within 10 to 15 minutes at the most.
All right.
And then we can continue tomorrow,
All right.
if that's okay with the tribunal.
Okay.
So, I want to go back to this Persco graph that we have, which is exhibit R139, page 6. So, let's forget for a minute that there are other categories that are not listed here that would not be even a resource. So if I'm looking at this chart and considering this, considering a pendulum of a risk associated with the development of a mining project, which would be the riskiest category, so to speak?
Well, that's a bit of a leading question, isn't it? You asked me
I get entitled to do that.
What's sitting at the bottom? Well, it's me. Well, it is the inferred, but it's the inferred is actually it's the first serious rank.
I understand, sir. I just want you to focus on this figure.
Yeah, but it's actually a very unfair question because it's not showing everything. And to answer that fully, I'd like to actually read the Crisco report because I'm sure these other elements are in here.
I don't necessarily think that is necessary because my question is focused on this one figure. I'm sure that if council has some other questions, he can address that.
Then
when he gets
it's
to
the inferred. No, it's not. It's the exploration results is the lowest.
Okay, and then after the exploration results, we would have what?
The inferred.
The inferred.
Because I didn't notice earlier when I looked, but above here you actually have exploration results, which is one of the classifications I gave you earlier on that chart.
Okay. Now, I'd like to draw your attention to tab number 59, please. Now, this document, which is Exhibit R109, the tribunal, and you may have, I believe you were present when we were asking Mr. Anderson about this document, and this is a communication made by Belmont to its shareholders. Are you in front of the document, sir?
Yeah, number 59.
59, correct. Let me see, how much?
Would you like me to read it or?
Yeah, it starts with information circular.
That's the page I have.
Okay, then I'd like you to go to page. I'd like you to go to. I'm sorry, I got it. Page 10 on that document. Let me know when you're there, sir. So, Mark 10, top right-hand corner. You see that?
No, I was just getting to it.
Oh.
You bear with me, I have not seen this document before. before I leap into, okay, page 10?
Excuse me?
Yes, I'm on page
Oh,
10.
good. Can you please go to the second full paragraph that starts with the mineralization? And then if you go to,
That's the end.
it's page 10.
We have four, okay, we see.
As outlined.
It's
Yeah, the
down
one
the page
before
for
us,
us.
the one before us.
Yeah, so if you go to that paragraph and you go to the second to last sentence of that paragraph, starts with the resource. You see that?
The second paragraph,
No.
No, down.
The last full paragraph starts with the
Right, sorry.
mineralization.
yes,
And then the second full sentence, the second to last full sentence of that paragraph, I'm sorry.
yeah, the top offer OPG in German. No, the resource appears to
Correct.
the writer to correspond to a drilled inferred resource.
Correct, and that would be the category we were discussing earlier, right? That in that figure 1 that we saw, the Crisco standard would be one of the high risk.
No, I think you're misguided. It's not a high-risk category, it is a category. It's like comparing colors, which is the brightest color. Inferred has least information compared to indicated and measured. But to bring a deposit to inferred can take years and can take massive investment depending on the mineral. But once you've got it to inferred, you have then the confidence. This is when the businesses go to investors.
I understand.
Usually as a junior company can bring it on to an inferred level, even not that far, but a good junior company can take something to inferred, then that's the time to start mining, to start developing the deposit.
I understand.
If it's not inferred, it's premature to develop
Okay,
the deposit.
I understand. Thank you. Now, I'd like to go back to your report, if I may. And it'll be the supplemental report. Actually, I misspoke, I'm sorry, it's the first report.
Thank you.
Page 16, under section 6.4.
Mhm.
There are 2 bullet points. The second one says, the fully explored refers to an area that has some boreholes, but not sufficient to clearly define the area, nor establish a resource or mineable reserve. You see that?
Yes.
Okay. So if we go back to the Crisco figure that we were earlier,
Mhm.
then according to your assessment, this poorly explored area would not even make that figure, would it?
Correct.
And this poorly explored area refers to the entire eastern area of the deposit, does it?
Not the entire eastern area, no.
Okay, right next to that page, on page 17 of your report, there's a graph.
Yes.
And it has what you called earlier an envelope, I believe.
Yes.
Which would be the poorly explored in that graph?
It's not indicated on that graph.
And
What I've indicated on that graph is the east and west to be compatible with the mapping of Rossman's.
And if you had to identify the poorly explored for us on that graph, which would it be?
Oh, it would be the core of the east.
The core of the east.
Core of the east.
Okay, and I see there are some, I believe our coordinates here, right on that graph. You see it goes from 312, 100,000 all the way to 315, 100,000.
Yes.
The core would go, would it start at the end, at the far end of the left end?
What would?
Where would the core start? I just want to make sure that I delineate the core of the east that you were referring to earlier.
You could say everything to the left-hand side of that middle hole there. There would be a portion that.
I'm sorry, you're gonna have to, if you can verbalize exactly
Okay.
where the line is, just,
If somebody could tell me the hole number, I think it's hole number 10, I can look on the plan.
Well, we have coordinates there. If you look at the coordinates, the top
Sorry.
axis,
Everything to the east of borehole 40 is definitely poorly explored.
okay, but on this graph specifically, I'm trying to just map it out on this graph.
But that is on the map.
I'm sorry, I don't know that my figure shows a borehole number.
Yes, it's on the top, there's a number on the top.
So it would be the second borehole
Yes.
from the left.
That's what I was pointing out, yes. I'm sorry I couldn't read the number till I got to the chart.
So everything from that second borehole to the left, you would classify as not sufficient to establish a resource of mineable reserve, correct?
Correct.
And then everything to the right would be an inferred?
No, it's not that simplistic. It would be based around the holes. What I defined is that the eastern area is about 500,000 tons of mineralized rock. 500,000? More than that, sorry, 500 million mineralized rock. So the east and the west volumes of rock is roughly the same, But what is being well explored is the western area. The western area, which is defined on map 5.1, the western area is certainly well explored, but well explored on the nature of having holes on the boundary, that well explored would fall into the eastern area slightly.
And when you say well explored, are you talking about an indicated mineral resource?
It's in the main because they carried out a systematic drilling pattern.
So you don't believe that it is an inferred? That well-mined area?
No. The well-mined area,
I just want to make sure what the well-mined area for you, if it's inferred or indicated
it's
resource?
indicated. The yellow area is what I would look to be indicated with a number of holes there.
So your assessment differs from from the document that we saw earlier that Belmont circulated to its shareholders. And I have it here, which is R109, says inferred resource.
But inferred indicated is better than inferred.
I understand that,
Yes.
but they didn't tell their shareholders that it was indicated.
Yeah, but no, there's only what they were telling their shareholders, that whole western area was inferred. They were telling their shareholders that, from what I read here, is that whole area is the inferred, and that inferred area, I haven't even gone that far to explain that in volume is colossal. I haven't even gone to that extent.
Okay,
I've only picked this small area, which is about 1.5 million tons of talc, and upgraded it because of the concentration of drilling, also the bulk sampling by the big boreholes, and then the testing of the bulk sampling to give me the confidence that I can actually process it and handle it commercially.
now, I want to go back to R109, and I think this is the last topic I'm going to address today. Where we saw that the document says inferred resource. If you can, I'll give you.
Which document am
It's page 10,
Oh, sorry, yes.
R109.
Yes.
If you want, I'll let you read this, and then I'm going to ask you a question, and I want you to tell me there where if you see the term indicated resource.
No.
You
I
don't?
already read it. It's not indicated, it's not there. They're showing that whole area as inferred.
Okay.
But
Thank you.
a greater area than I've indicated is inferred.
Okay. But it doesn't appear here,
Appear where? Give you
in this document 109 that we just saw.
Indicated does not appear in
Thank you.
here, only inferred.
Thank you.
Agreed.
I think we're done for tonight, Mr. Chairman.
Thank you. So, we meet tomorrow, 9, continue your examination.
Thank you very much. Sorry, is it possible for me to read the Kisco preamble before tomorrow morning as it's being elaborated on and be discussed? Could I have a copy of that, please, to take away?
Yeah, it's part of the record. Yeah.
Thank you.
think, Mr. Chairman, since we're gonna be breaking for the evening, if we've been instructed with the expert not to discuss the testimony.
I don't give that indication to experts.
Okay.
Because they're independent, but, of course, you have to
Who have I got to discuss it with?
act as independent.
I can discuss it.
We talked about it.
Is that an invitation?
Thank you, Mr. Chairman.